Good afternoon, everyone. Welcome to the Dallas Volunteer Attorney Program's monthly CLE on evictions we're doing this month. For those of you that are not familiar with DVAP, as we affectionately call ourselves, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their case pro bono. We handle a wide array of cases ranging from family law to probate to landlord-tenant issues and also evictions. And we have seen a number of evictions increase, especially since the pandemic is slowly winding down and the eviction moratoriums that we had in place have ended. We do have an eviction clinic that's held at least once a month at one of our JP courts, and we're always looking for volunteers to help staff that and help our clients with their eviction hearings. So today we are very blessed to have Kalisha Rutledge here to speak with us. Kalisha is a managing attorney with the Legal Aid of Northwest Texas in our Home Preservation Project office. She has been with Landwidth for 13 years and has specialized in landlord tenants, law, and guardianships. She's held a wide variety of positions here at Landwidth, from staff attorney to mentor for our volunteer attorneys for their landlord tenant cases. She served on several task forces and has been Landwidth's housing practice team leader for several years before she was promoted to managing attorney of our housing preservation project. During the last 2 years, she and her staff have coordinated community education for tenants facing evictions by doing outreach and providing same-day representation at various courthouses across Legal Aid's service area, which stretches all the way from Dallas to Amarillo. So she is an expert in evictions, and if you have questions during the presentation, please put them in the Q&A section at the bottom, and Lakeisha will try to get that answered at the end. So without further ado, I'll turn it over to Kalisha.
Thanks, Kristen. So today I'm going to be talking about the eviction process, what I like to title Evictions 101. So we're going to get started. And the first thing that I'm going to do is give you an overview of the eviction process. So how does it start? First, there is a tenant and they have to violate the lease agreement in some type of way, allegedly, or they are a holdover tenant. Then that tenant should be given a notice to vacate. The landlord is going to file a petition for eviction in justice court. A trial date is going to get set and citations are going to get issued and delivered to the tenant. That eviction trial is going to be held in justice court, and it has to be held within 10 to 21 days. And the only thing that the judge is really going to be looking at is it an issue of possession, and is rent owed? Then the landlord is either going to get a eviction judgment for possession, or it's going to get dismissed. Whichever party loses, either party can appeal within 5 days to county court. If there is no appeal, or rent isn't paid into the registry, and we'll talk about that later, the landlord is going to obtain a writ of possession. And I'll talk about what a writ of possession is. And after that writ of possession is issued and signed by the judge, the constable is going to go out and enforce that writ of possession. So it all starts with a lease agreement, which can be written or oral. So the lease, how do you tell if there's a lease agreement? You want to make sure that there is a landlord-tenant relationship. That lease agreement can be written, it can be oral, and if it is an oral lease agreement, then you would want to have some type of proof that you and your landlord entered into an oral lease agreement. That proof can be a text message where they sent you saying, oh yeah, rent this month is $400, it's due on the 1st or it's due on the 5th. But an oral lease agreement is a thing. And when I say lease, it's basically any written or oral agreement that's between a landlord and a tenant that establishes or modifies the terms, conditions, rules, or other provisions regarding the use and occupancy of a dwelling, and that's straight from the property code. Sometimes there isn't a landlord-tenant relationship, but someone can be living in a house and they might be a guest or an invitee. And if that is the case, there is no need to do a formal eviction process. Although I will tell you that most police officers, if they get called out, they are not going to touch it with a 10-foot pole. They're going to tell the person, I'm sorry, we can't help you. You need to evict them, even though you really don't need to evict them. But that's the thing. Some examples are, Auntie M, she doesn't have to evict Dorothy from her house. She technically could just kick her out and change the locks, but to make sure everything is done by the books, and to protect themselves from damages is probably always the best idea to do an eviction. Sometimes we have guests that live in motels or hotels, and there's always an issue of, are they a guest or are they really a tenant at that hotel? And it kind of depends. If they've been there for 5 years and they pay rent monthly, there may be an argument that that is a landlord-tenant relationship and they are not just guests living at that hotel. Now, if they pay rent weekly or daily, chances are they're probably going to be considered a guest. A lease agreement can be for a fixed term. They can be a tenancy at will issue. And a tenancy at will is one where there's a landlord-tenant relationship, but there aren't specific terms of the tenancy. And this is important to understand that a verbal agreement to let a family or friend stay with you may create a tenancy at will and require you to do the formal eviction process to get them to move out of your home if you no longer want them there. You can also have a periodic tenancy, which is something like month to month or week to week. Some practical tips. If there is no lease agreement, then that means title may be at issue. This comes into play a lot of times when there are siblings that are taking care of elderly parents. Maybe that elderly parent passes away and the sibling that was living in the home taking care of mom maybe isn't the power of attorney or the executor in the will. And then someone comes along and they're trying to evict their brother or sister from a house that was owned by mom. Then sometimes you might have to look who is the owner of this home, who has the superior right of possession, and title might be at issue. And if title is at issue, then eviction suit cannot continue or proceed. Is going to be abated, and the judge is going to tell them, you need to go to probate court and you need to figure out who's the owner before you proceed with this eviction. Sometimes tenants don't get a complete copy of their lease agreement. If that's the case, an eviction suit can be abated or put on hold if the landlord does not provide the tenant a copy. But this does not apply to non-payment of rent cases. If it's a non-payment of rent case, the judge is not going to say, oh, this eviction is going to stop. You give them a copy and then we'll proceed. The judge is going to continue with the eviction. And I think that the reasoning behind that is, when the lease was entered, you knew what your rent was when you signed the lease agreement. But it's a different case when it's a lease violation, and maybe that lease violation was in the program rules, or if it was somewhere in the lease agreement, they want to make sure that the tenant has a copy of that so that they can use it for their defense at the hearing. So what type of violations can you have? It can be a non-payment of rent lease violation, and then there's everything else. So when it comes to non-payment of rent, the courts are very strict. If a tenant is a day late or $1 short, they can be evicted for non-payment of rent if they don't pay on time. There are lots of lease agreements that will give you a grace period. Maybe rent is due on the 1st, but you have a grace period to the 5th, and they're not going to charge you any late fees if you pay between the 1st and the 5th. A lot of tenants get caught up that if you don't pay your rent on the 1st, as it said in the lease agreement, on the 2nd, they could file an eviction against you or start the eviction process against you, even if the lease agreement says that you have a grace period until the 5th. Rent is still due on the 1st. The late fees, if a landlord wants to ask for late fees in an eviction proceeding, those late fees must be in writing in a written lease agreement. If there is an oral lease agreement, the landlord is not going to be able to get any late fees. You always want to also check for a payments application of funds clause in the lease agreement. And that comes into play sometimes when, let's say, rent is due on the 1st of each month and it's $500. And if you don't pay on the 1st, then there is a late fee of, let's just say it's a blanket late fee of $50 per month. If a tenant pays their, let's say, May's rent on the 2nd, their rent was $500, but now they paid it a day late. So really they owe the apartment complex $550. If they only pay that $500 on the 2nd, when June comes around and they go to pay another $500, the landlord might take that $50 out of June's rent and apply that to May's late fees. So then June's rent is going to be short. And then that tenant is going to be in the hole for another late fee of $50 because their June's rent is short. So you want to make sure that they're to check to see if there's an application of funds clause in the lease agreement. There's no obligation to remind a tenant about late fees once it is in writing in that lease agreement. So those are the non-payment of rent violations. Then there's what you get into kind of the category of everything else. If there is criminal activity in the unit, if they're using drugs, if they damage property, if they have unauthorized occupants or unauthorized pet, those are things that could cause a tenant to violate their lease agreement and start the eviction process. So what are some practical tips? Make sure you read the lease agreement to make sure that it is an actual violation that is listed in the lease agreement. You want to see if there is a reasonable accommodation that could excuse the violation. Some examples of reasonable accommodations. Let's say rent is due on the 1st, but the tenant receives Social Security disability, and they get paid on the 3rd of every month. So that means that there is no way that they're going to be able to pay their rent on time on the 1st because their check doesn't get delivered to them until the 3rd. That tenant can ask the landlord for a reasonable accommodation to pay their rent on the 3rd without any late fees instead of the 1st. Some other reasonable accommodations: if a tenant has a dog, but that dog is an emotional support animal, then it's not going to be considered a pet and they can't charge for pet fees or pet rent. Another reasonable accommodation that I've used in the past, sometimes there are tenants that are disturbing the peace, or maybe the landlord says they're harassing the other tenants. Let's say that tenant yelled at a neighbor, but the tenant suffers from bipolar disorder and they were temporarily off their medication. You can ask for a reasonable accommodation request to say, hey, my tenant has this disorder. They were off their meds for this month. Can you please give a reasonable accommodation and basically overlook this lease violation. But you would, of course, want to make sure that you get permission from your client before you proceed forward with that. And you don't have to tell the landlord the actual disorder unless they ask. And we're going to talk about some reasonable accommodation specifics on the next slide. So the Fair Housing Act prohibits the refusal to make reasonable accommodations in the rules, policies, practices, or services when such accommodation may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. So what is a person with a disability? That can be an individual with a physical or mental impairment that substantially limits one or more of their major life activities. It can be an individual who is regarded as having an impairment. And it also can be an individual with a record of such impairment. And I want to make it very clear that the person does not need to be on disability benefits to meet the definition of being a person with a disability. The reasonable accommodation is a requested change, an exception, or an adjustment to a rule, policy, practice, or service. And that reasonable accommodation request can be made verbally, although I'm a firm believer that you need to do it in writing, which is the second way, just so that you can have proof that you did it. It can be accompanied by a letter from a medical provider, and it can also be made at any time before the tenant is physically evicted from the rental property. So you can bring it up when they get the lease violation. You can bring it up when they get the notice to vacate, which we'll talk about in a minute. You can bring it up for the first time at the actual hearing and ask for accommodation. If they lose the hearing and they're ready to appeal, you can ask it at that time. You can ask it anytime before they're actually physically removed from the property. And I will tell you that a lot of landlords get very scared and apprehensive when you start throwing around reasonable accommodation requests. So we're going to talk about the demand for possession or the notice to vacate. That notice to vacate has to be an unequivocal demand for possession. It needs to be in writing. It should not be via text message or via email. It should be a piece of paper, and it has to be delivered a certain way. It has to be either delivered to someone in person that is the tenant or is 16 years or older that resides at the property. So you can't give the notice to vacate to any visitors. It has to be someone that resides there. You can also deliver it by affixing it to the inside of the front door. And they do that because they don't want people from other units just coming by the door and just taking it off, and that tenant never knows that they got a notice to vacate. So that's why they want you to put it on the inside of the door. You can also send it via mail. It doesn't have to be certified mail. It can just be via regular mail. Or they can affix it to the outside of the front door, but it has to be in a sealed envelope marked important document, and a copy of it needs to be put in the mail the same day. If both of those things don't happen, then the notice to vacate was not delivered properly. So what are some practical tips regarding the notice to vacate? You want to make sure that if you are representing tenants, look at the notice to vacate and make sure the landlord gave enough notice. And the lease agreement is going to control how much time period they have to provide in the notice to vacate. If the lease is silent, the Texas Property Code says that they have to give the tenant at least 3 days to move out in the notice to vacate. If there is a subsidized property, the notice might have extra requirements that are attached to it. If the tenant has one of the standard TAA lease agreement, that notice to vacate is a 24-hour period. You also want to make sure that the notice to vacate was delivered properly and it can be verified that it was delivered properly. If it was sent via text, via email, it does not count, even if the tenant received it. That's not a proper form to deliver it. If the landlord slipped it under the door or in the crack of the door, or they rubber banded it around the doorknob, that's not a proper way to deliver it. And you want to have the tenant either take a picture of the notice to vacate, or you need to ask them to basically reinvent how they found the notice to vacate and take a picture. And you can take that picture and show it to the judge. You know, this is how I found my notice to vacate. And if you have the notice to vacate that was folded and, you know, messed up from being slipped under the door, take the actual original in there also. At court, if there's a maintenance man or another employee that delivered the notice, but they don't show up to court to testify to how they delivered that notice, then you can ask the judge to basically dismiss the lawsuit, because, you know, there's nobody there to verify how it was delivered. You also want to make sure that they waited the correct amount of time that they stated in the notice to vacate before they file the lawsuit. So, for example, if they gave you 30 days to move out, but then they file their eviction lawsuit on the 20th day, then they file their eviction suit prematurely, and you can ask the court to dismiss it because they didn't give the tenant the amount of time that they gave in their notice to vacate. While we're talking about the city of about a notice to vacate, I wanted to make note that there is a notice that pertains to City of Dallas residents only. And these are people that have actually Dallas, Texas in their address, not Dallas County. They actually have to be a resident of the city of Dallas. There is an ordinance, and I'll talk a little bit about it later as well. That's called a notice of proposed eviction that City of Dallas owners must provide the tenant before they give a notice to vacate. Once they send that notice of proposed eviction to the tenant then has 10 days to respond to the landlord by giving them a rental assistant notice. If the tenant doesn't give the landlord a notice, then the landlord can then give the notice to vacate and proceed with the eviction. If the tenant does give notice to the landlord, then they're going to get an extra 60 days from the date that the notice of proposed eviction was delivered to, one, cure the rent, or to respond with the tenant's rental assistance application. And that landlord is not going to be able to give them a notice to vacate until that 60 days has expired. So it's a very fast moving process. Notice of proposed eviction, the tenant has 10 days to respond. And if they do, they get an extra 2 months to try to cure the rent or get their rental assistance situated before the landlord can give them a notice to vacate. If the tenant does give that rental assistance notice to their landlord before the landlord has the opportunity to give them a notice of proposed eviction, then the landlord has to provide the tenant a right to cure any delinquent rent or respond with the tenant's rental assistance application for 60 days. So basically, if the tenant beats the landlord before they give the notice of they send out the notice of proposed eviction, then they get 60 days also. If a tenant makes an application for rental assistance, or they already submit an application for rental assistance, and they provide that rental assistance notice to their landlord and it's approved, the landlord has to accept the program payout schedule, and they cannot take any action on an eviction proceeding except if that eviction proceeding is for a lease violation that is something besides non-payment of rent or fees. That City of Dallas notice has to be in writing. It has to include the notice of rent delinquency, and it also has to request the tenant to respond in writing and to let the tenant know of their right to respond to the deadline stated. And it also has to include options on how to resolve that delinquency. And it has to be delivered in the same manner as the notice to vacate. So in person, hand delivery, posted on the inside of the door, sent via mail, or posted on the outside of the door in a sealed envelope marked important document, and a copy placed in the mail the same day. So now let's get into the meat of it. We're going to be talking about the eviction suit, which is called the forcible entry and detainer suit, or an FEND suit. And with the eviction suit, the landlord has the burden of proof. If only one party shows up, then that party is going to win by default. The loser, of course, is going to pay the court costs and attorney fees if awarded. And the court cannot award anything other than possession of the premises and unpaid rent if non-payment of rent was alleged. So the landlords shouldn't be able to get any type of late fees, any repair costs mixed into the eviction suit. It should only be possession and rent. That eviction hearing is going to be held not less than 10 days and no more than 21 days. The lawsuit has to include when and how the notice to vacate was delivered. The judge will sign an alternate method of service, and that needs to occur at least 6 days before the day is set for trial. And you're not required to have an attorney represent you in these lawsuits. You can represent yourself, your friend can represent you. You don't have to be an attorney. Some practical tips. You don't want to give the landlord ammo for their case. Make them prove it up. Make sure you prep your clients and any witnesses that you take. Advise them to keep quiet. Make sure that they're not doing the sigh. Tell them don't roll their eyes and only answer questions that have been directed to them, and that they don't need to elaborate unless they were asked to do so. You have to know when to negotiate, and you can consider an eviction hold-off agreement. Basically, I understand you filed an eviction against me. I know I owe rent. Can we set up a payment plan and I agree to pay this amount each month and you agree to dismiss the lawsuit? Or, I know you're unhappy with me. I'm unhappy with you. I want to just move out. If I move out by this date, will you agree to dismiss this eviction? Those are examples of an eviction hold-off agreement. And also there are no counterclaims in an eviction suit. You would have to file a separate lawsuit for that. So the judge only wants to talk about rent and who has possession. He doesn't want to hear about repairs that haven't been made, or you didn't pay your rent because of repairs. He's not going to want to talk about that. So what are some defenses to an eviction? Some common defenses, if it's a non-payment of rent, but you paid your rent, that's a no-brainer. You can also use retaliation as a defense to an eviction, and I've been successful with this in the past. Sometimes landlords are upset because you've asked them to make repairs, and they decide that, oh, well, you know what, next month, you turned in your rent, but I'm sending it back to you. And then I'm going to evict you for non-payment of rent. Now you're retaliating against me because I asked you to make a repair, which I'm allowed to do under the lease agreement and in the property code. I've also had a tenant who called the police on their landlord because they were, beating so hard at their door. The police came out, landlord got upset, and then, filed an eviction lawsuit against them. And I was like, the only reason why she did this was because she's mad because my client called the police on her. And I won, and it got dismissed. If the notice is defective or they didn't send notice at all, that's a way to get the case dismissed. If they're not able to prove up how that notice to vacate was delivered, case should get dismissed. Sometimes there is discrimination that can be a grounds for eviction. And if that's the case should get dismissed, and you might want to see about notifying fair housing about them and making a complaint. And sometimes people do that, and that's the reason why the landlord files an eviction, and then you would have discrimination as a defense and retaliation. There's novation, which is if I signed a lease agreement in 2022 that ended, let's say, January 1st of 2023. If I, let's say, got the police called out against me in December of 2022, but you signed a new lease agreement with me in January 2023, you're not going to be able to evict me about a lease violation that happened under the 2022 violation unless that is written in your lease agreement. There's also it's not the correct party that they file the lawsuit against. Sometimes landlords will file their eviction in an assumed name or a name that's not on the Secretary of State's website. And if they're not the correct party, then you can have that dismissed. Sometimes an agent of a landlord will file it in their name instead of the landlord's name and put themselves as agent, and you can get that dismissed. As I stated earlier, if title is at issue, you can get the case dismissed, or at least at minimum, you could probably get it abated while you guys figure out the title. Unclean hands, if the landlord, my situation that I said earlier, say you pay your rent on the 1st and on time, and your landlord sends your rent back to you, and then they later say, oh, well, you know what, you didn't pay your rent, but I turned in my rent and you sent it back to me. That's basically unclean hands, and they're not going to be able to evict you if their hands aren't clean. If they file prematurely before the time stated in their notice to vacate, that's a defense. And also, if a landlord is trying to evict a victim of domestic violence or stalking, there might be a defense if you have the right documentation. So let's talk about if you lost your eviction and you want to help somebody appeal. There is a 5-day deadline. That deadline includes the weekends and holidays. So Saturdays, Sundays are included. If your hearing is on a Thursday, then day 1 starts on Friday. If the court closes before 5 p.m. on the due date, then there is a deadline extended to the next business day. So there are a lot of JP courts that close before 5, and tenants actually get 6 days to appeal instead of 5 days. I always tell people to go on the 5th day because I don't want there to be an issue of, oh, well, no, our lobby. Yes, we stopped taking phone calls at 5, but our lobby stays open for appeals. So I always just say the 5 days and only use the 6th day unless I'm trying to slip somebody in. You have to post either a bond or file an affidavit. And that's basically a statement of inability to pay costs. If the case is for non-payment of rent, you have 5 days to file your statement of inability to pay. Once you turn that in, you will have another 5-day deadline to post 1 month's rent into the court registry if the tenant plans to stay in the unit while the case gets appealed from JP court to county court. At county court, it is a trial de novo, meaning you get a whole do-over of the trial, and that the tenants can request that an attorney ad litem be appointed for them if they filed a statement of inability to pay, but the court is not required to provide the tenant with an attorney ad litem. I have seen some judges give attorney ad litems to people that are going up against the Public Housing Authority, or if the tenant has a disability, then sometimes they will appoint an attorney ad litem. So since COVID-19 hit, there have been a number of different laws enacted to help with tenants. There's been the CARES Act. There's been numerous emergency orders issued by the Supreme Court of Texas. There's been the Texas Eviction Diversion Program and the City of Dallas notice of proposed eviction. So first, I'm going to talk about the CARES Act. This was to help borrowers with federally backed multifamily mortgage loans who had experienced financial hardship caused by COVID-19. And it allowed them to request a forbearance in their loans through the earlier of the termination date of the national emergency concerning COVID-19 or June 30th, 2020. So I'm sure you're wondering, well, it expired in, June 30th, 2020. Why is this still come into play? Well, following the expiration of that forbearance in 2020, a borrower may not require a tenant that is living in a home that would have qualified them under the forbearance. They can't require the tenant to vacate that unit before a date that is 30 days after the date on which the borrower provides the tenant a notice to vacate. So basically, if you had a federally backed mortgage that qualified you to get a forbearance, you have to give that tenant a 30-day notice to vacate. Not a 3-day, not a 24-hour notice, but a 30-day notice before that. And this is still in effect. It's still a defense that we use today. Your home qualified you under the CARES Act. You have to give your tenant 30 days. You only gave them 3. Case gets dismissed and you have to start over. So how do you know if it was a CARES Act covered property? I have put some websites in here for you to look. There is the National Low Income Housing Coalition has a website that you can check. Fannie Mac borrowers have their own website that you can check. Freddie Mac has a website also, and the Federal Housing Administration has a site. So you would really want to check all 4 sites to make sure to see if that property is a CARES Act covered property. I do want to mention that the FHA tool, it includes properties with FHA multifamily mortgages or in HUD's multifamily programs, but not all the properties are part of HUD's public and Indian housing programs are listed. Sometimes it requires you to look up the deed to see who the owner is, and requires a lot of research, but usually they're up on those websites for you. So now I want to talk about the latest Supreme Court of Texas emergency order. They have stopped numbering the emergency orders. I think the last time I remember that there was a number was like 50, emergency order number 50. So I guess they got tired of numbering them, but the recent emergency order, well, not recent, but the renewed emergency order basically states that if it is a non-payment of rent eviction citation, it must include the following phrase: you may be able to have some of the rent you owe paid and stop your eviction. At the trial, the judge must allow representatives from legal aid organizations to be present in person or remotely to provide information, advice, intake, referral, or other assistance to eligible litigants. The judge also should confirm whether or not the plaintiff has any pending applications for rental assistance or has provided any information or documentation directly to a rental assistance provider for purposes of receiving rental assistance on behalf of that tenant. If rental assistance is available, then the landlord and the tenant or the judge should discuss the available rental assistance programs and procedures. Should ask the parties if they're interested in participating in those available rental assistance programs. If the plaintiff does have a pending application for rental assistance, or the plaintiff and the defendant express the interest in participating in rental assistance program, then the judge must abate that case for 60 days, basically put it on hold. They need to make all the court records and the files confidential, and they need to inform the parties of any extension, reinstatement, or dismissal procedures. Sorry. The judge may extend that 60-day abatement period at the plaintiff's request, not the tenant's. Each extension must not exceed 60 days. And if the plaintiff wants to reinstate an abated case, then that plaintiff must file a motion to reinstate with the court. And they also have to serve a copy of that motion to on the defendant. That motion must show that that tenant's rental assistance application or participation has been denied, canceled, or withdrawn. And after filing and serving that motion, the judge needs to sign and serve a written order. And that order basically has to state that this eviction has been reinstated. He will then need to set the trial date and state procedures for the action to proceed. And then he's going to make all the court record and the files non-confidential. If the plaintiff does not file a motion to reinstate within that 60-day period, then the judge must dismiss the case and any claims, rent and non-rent, with prejudice the day after the abatement period expires. And neither party needs to file a motion or make a request, and that the file is going to stay sealed. So basically, if the case gets abated, there's going to be a 60-day period while the plaintiff and the tenant try to get some type of rental assistance paid out. If that 60 days runs and the landlord then asks the judge for that case to be reinstated on the docket, the case automatically gets dismissed with prejudice. And that tenant is not going to be required to pay that land or pay that judge for the rent because the case has been dismissed with prejudice. Or I want to say that the landlord is not going to be able to refile a new eviction for those same monies. The parties can inform the judge of their willingness to participate in the Texas Eviction Diversion Program, which is basically the rental assistance program, and I'll discuss it a little bit more. So long as the writ of possession has not been issued. And a writ of possession is basically a court order signed by the judge saying, yes, constable, you can go remove this person from the property. The judge is going to set aside any judgment. They're going to make the records confidential, and they're going to sign a written order stating procedures that apply to reinstate the judgment or dismiss the eviction. This latest emergency order was renewed on April the 28th, and it expires July 1st, unless it is extended by the Chief Justice. So Texas Eviction Diversion Program, TEDP. It's basically a program that's helping the renters stay in their homes, catch up on missed rental assistance payments, and avoid an eviction on their records. On November 5th, 2021, the Texas Rent Relief Program stopped accepting new applications for rental assistance. They reopened their portal in March of 2023 when they got a little bit of extra money, and they immediately closed it within a week or so because all of their funds had been tied to applications. If you want more information about TEDP, I listed the website here. But how does the TEDP work? Basically, both parties have to agree to try to get rental assistance to try to resolve that eviction suit without proceeding with the trial. There is a agreement that you can sign and file with the court, letting them know that the landlord and the tenant both want to participate. And that case is going to be abated while the parties seek the rental assistance. And if it's successfully completed, the case is going to get sealed and dismissed. So I mentioned earlier about the City of Dallas ordinance. This is just a little bit more in detail. The purpose of this notice was to enable the residents that are unable to pay their rent. The city wanted them to be able to work collaboratively with their landlords to make some type of payment arrangements. Again, it only applies to City of Dallas residents. And basically the landlord, before a landlord sends the notice to vacate for non-payment of rent to a tenant, they have to first send this notice of proposed eviction. That notice is going to let the tenant know that they have 10 days to provide documentation of rental assistance. And that is some type of verifiable confirmation of a rental assistance application from a qualified source by any person to the landlord. It can be text message if the rental assistance provider sent the landlord a text message or an email or any other type of written delivery. The tenant can provide that to their landlord. If the tenant doesn't respond, the notice to vacate can be given and the eviction process proceeds forward. If the tenant does respond, they have that 60 days from the date that they receive the notice of proposed eviction, and they get the opportunity to cure any delinquent rent or respond with information regarding the tenant's rent assistance application. If they do either of those things, then the landlord cannot give them a notice to vacate until the 60 days has expired, and then they can proceed forward with the eviction. Unless the eviction is for something that is not non-payment of rent. If it's for an imminent threat of physical harm or criminal activity, then they don't have to wait the 60-day time period. They can proceed forward with the notice to vacate. Or if they're asking for rent and something else, they don't have to wait the 60 days. If that tenant is approved for rental assistance, the landlord has to accept the program schedule for repayment. They can't take any action on any eviction proceeding unless it's for an eviction that is something involving non-payment of rent. The notice of proposed eviction has to be in writing. It has to contain certain language, and it can be delivered in any manner that the notice to vacate can be delivered. If the tenant's application for rental assistance is denied, withdrawn, or for some reason it can't be processed because of the tenant's failure to provide information or cooperate in the process, then that 60-day time period is going to end and the landlord will be able to proceed forward with the eviction. If there is a notice to vacate that was given to a City of Dallas resident before the expiration of the time period, then that notice to vacate has no legal effect, meaning they will not be able to use that notice to vacate to prove up their eviction in their eviction hearing. There is nothing in the ordinance that relieves the tenant of their obligation to pay rent. This ordinance will expire whenever a permanent eviction order is adopted. And I do want to note that there are efforts by the government, the Texas government, to bar cities and counties from enacting tenant protections against evictions that are not in the property code. So they basically want to kind of do away with the City of Dallas ordinance. Next, I'm going to talk about federally subsidized housing, vouchers, and public housing. A federal subsidy is any type of public housing, subsidized housing, vouchers. If you hear Section 8, if you hear VASH, which is the Veterans Affairs for Supportive Housing, just know that generally there are greater protections and greater protections for the tenants / participants and more obligations on the owners. And you want to make sure that those tenants seek legal assistance immediately. How do you tell if it's public housing or Section 8? With public housing, the landlord is usually the Public Housing Authority or the PHA. And they have to evict in accordance to federal rules. There's usually a 10-day notice for proposed lease termination. The tenant has the opportunity to request to meet with the landlord before an eviction is filed to try to address the issues. And the landlord has to do this before they can send any type of notices that are required by the lease agreement, the state or federal law. Then the tenant may have a right to request a grievance hearing to talk about it before an eviction is filed, unless it involves criminal activity, and then they're not afforded that opportunity. Section 8. Here the landlord may be the Public Housing Authority, or it may be a private owner. There's going to be two agreements, well, a couple of agreements. There's a lease agreement that controls, unless there is a conflict between the lease agreement and the housing assistance payment contract, which is HAP, and then the HAP controls. So basically there's a lease agreement between the tenant and the owner. And then there is the HAP contract, which is an agreement between the Public Housing Authority that is issuing this voucher and the owner, and the Public Housing Authority and the tenant. Also, both parties have to sign the HAP contract. So if there's ever a disagreement about what's going to control lease agreement or HAP contract, it's going to be the HAP contract. Here, if the landlord sends a notice to vacate to the tenant, they also have to send a notice to vacate to the Public Housing Authority or whatever entity is subsidizing that voucher or managing that voucher. And the landlord cannot evict a tenant for non-payment of the Public Housing Authority's portion. So if I have a tenant and I have a voucher and the Public Housing Authority pays $900, I pay $100. If the Public Housing Authority does not pay their $900, I cannot get evicted for their failure to pay their $900. I can only get evicted for me not paying my obligation, which is the $100. Some practical tips. Make sure that you understand the lease, or that tenants understand the lease agreement. They follow the rules. They know the law or know someone that knows the law. Always make sure to get everything in writing. Pay rent in full. Document everything. Keep copies. Keep a paper trail. Communicate with your neighbors. Communicate with your landlord. If needed, try to negotiate a voluntary move-out agreement. You can have a backup plan, talk to an attorney, make sure they show up to court and show up to court early, and ask for a continuance if needed. I have listed a lot of the resources that I use in my practice and I provide to my attorney so that they can use in representing people that are getting evicted. And I believe Maricela will be emailing this out to everybody. So this is just a list of all the things that we use. And if there are any questions.
Thank you, Kalisha. We do have a couple questions in the Q&A. First question, can you talk a little more about unclean hands?
Gotcha. It's basically when the landlords are trying to be sneaky, and they're trying to evict you for something that they caused. We usually see it when people, let's say, this is an issue I used to have with the Public Housing Authority back in the day. The manager at the apartment complex thought that it was her little fiefdom, her little kingdom. And if she got mad at a tenant, the tenants at that time, they were mailing their rent to a PO box. What that landlord would do was take the mail out of the PO box and send it back to the tenant. And then they would file an eviction for non-payment of rent. And their hands are not clean because my tenant tendered rent on time, but the landlord gave it back and is now evicting for that. Like, you can't have it both ways. If I paid my rent, then you need to accept it. You can't mail it back to me and then say, oh, you didn't pay your rent. It's basically when the landlord is aggravating the issue, or they're doing something that they shouldn't have to cause the eviction.
Next question. Clients who are being evicted over and over for non-payment of rent get a notice of eviction every few months from the apartment, but is never filed in court. How does the Dallas County 60-day notice work when non-payment of rent is an ongoing issue? And when does the 60 days start? Each time they get a new eviction?
So that is a problem. And you kind of just have to keep up when the notice of proposed eviction was given. That's when the 60 days start. And what notice to vacate they are tying to that notice of proposed eviction. If they give a notice to vacate in January of 2023, but then they send a notice of proposed eviction on May 1st, then they're not going to be able to use that notice to vacate that they sent in January, because the notice of proposed eviction wasn't sent until May 1st. So they're going to have to, give the tenant that 10-day time period, and then they're going to have to send a new notice to vacate. They're not going to be able to use the one that they sent in a prior month.
Okay. Have you seen any cases being dismissed by request of landlord once appeal has been filed and the tenant failed to pay bond?
Can you repeat that question?
Yes. Have you seen any cases being dismissed by request of landlord once appeal has been filed and the tenant failed to pay bond?
Yes, and that's an issue. Once the tenant perfects their appeal, meaning they file their statement of inability to pay, that case should still go up to county court. And if the JP is not doing that, then you kind of have to talk to the clerk and make sure that that is happening. Now there are some tenants that will file their statement of inability to pay, but they don't want to live there. They don't want to live in the home, so they're not going to pay that 1 month's rent into the court registry. And they move out, but they still want their day in court. So that case still needs to get sent up to county court, even if they haven't appealed.
Okay. And then last question, is the notice for Section 8 eviction 30 days or 10 days?
So it depends on the type of subsidy. There's so many different types. Sometimes when people say public housing, that might be legit public housing. It might be subsidized housing. It depends on what program is administering it and what that type of subsidy is. But usually most notice to vacates for a public housing authority is probably going to be 30. Some days it's 10, depending on what type of subsidy it is. And I did include a chart, I believe, that had a lot of the different subsidies. And I think it has the time period for the notice to vacate on there.
Okay. Thank you, Kalisha.
No
So
problem.
it doesn't look like we have any more questions. So I want to thank Kalisha for presenting today, as well as thank everyone for tuning in. For those who want MCLE credit, the course number is 174-195-590. Again, that is 174-195-590. The CLE course number will be emailed along with the copy of the slides and supplemental documents that Kalisha has provided for attendees. So again, thank you everyone for attending, and we hope you have a good rest of your afternoon. Bye, everyone.